Hello again, my name is Mark Silver. I'm a forensic psychiatric social worker. I've done thousands of evaluations throughout the United States for immigration, criminal, and civil litigation lawyers. And today I'm going to be presenting on U and T non-immigrant visa petitions, psychosocial evaluations. The idea in all of my programs is to allow the attorney and here immigration attorneys to better understand the client's background and psychosocial issues as a means to allow the immigration defense attorney to advocate for the client in a more holistic way. That's true for today's presentation and for all the presentations I do. As I've said before, I've asked AILA National over the years to carry these clinical evaluation seminars for immigration attorneys in the United States. They don't seem to be interested, but I will tell you that local AILA chapters are quite interested, and I've done many of them over the years in different parts of the United States, which is great, and I've also done them privately for immigration law firms, and I'd be happy to visit your law firm by Zoom or in person to present these. There are a couple books that I recommend that I have. One is this book right here, Handbook of Mitigation in Criminal and Immigration Forensics, Humanizing the Client Towards a Better Legal Outcome. The reason I recommend this book is because there is a specific chapter on U-Visa petitions. Similarly, there are specific chapters on every CLE that I present in this book. Honestly, it's like the cheapest book you'll ever buy for your law firm. The other book I recommend is this, Psychosocial Evaluations in Civil Litigation. It's really for all lawyers, not just civil litigators. The good thing about this book, it has a very long section explaining how clinical psychosocial evaluations are undertaken. In other words, it's not just that I want you to sort of refer your case to a clinical or forensic expert to get an evaluation that'll help your client and help you understand the client better, but that you as an attorney will better be able to understand your client, having a sense of what kinds of questions to ask the client, how to engage with the client, and so on. I've spoken about this many, many times in countless lectures. The idea is that, we're not really taught in law school how to interview a client, what questions to ask, how to engage a client, and so on. And by the way, that's the most common reason for malpractice assertions. And this book will give you a better sense of not just how to engage the client, but the kinds of challenges and problems that can arise in a professional relationship and how to smooth them out in a way that avoids problems for you. The program today is to look briefly at legal background to the U visa, a T visa comparison, conceptualizing harm in the U visa cases, and psychiatric issues. I get many different kinds of U-Visa referrals. Overall, I'm told the most common case is spousal abuse issues. And as that is the case, I might be referring to them more frequently than other kinds of cases during this program. One thing I'd want to just say from the outset is that I really try to integrate theory with practice. And because of that, if you want a redacted copy of a case, that is a case that I've written with the actual names and birth dates and so on of the client removed, please email me or call me. If you send me an email, put in the subject line U-Visa or whatever so that I know what kind of case you're looking at. And in the email, put your signature and your name and where you're from. And I'm not going to send you any spam, I promise. It's just I want to make sure that I'm getting an email from an actual attorney and say that you saw my program and tell me where you saw it and that you'd like a redacted sample. And again, the whole idea here is to integrate theory with practice. So the idea here is that the legislation, was intended to strengthen the ability of law enforcement agencies to investigate and prosecute cases of all sorts of crimes, including domestic violence, sexual assault, trafficking of aliens, and other crimes, while at the same time offering protection to victims of such crimes. There's a few legal issues involved. The most famous is that the victim must provide a non-immigrant status certification, that is Form I-918 Supplement B, from a U.S. law enforcement agency that demonstrates the petitioner, in quotes, has been helpful, is being helpful, or is likely to be helpful in the investigation or in the prosecution of the criminal activity. The eligibility pertains to the applicant, of course, who must have been the victim of a qualifying criminal activity. The applicant must have suffered a substantial physical or mental abuse as a result of having been a victim of these criminal activities. This is a crucial notion because many of the clients we see have not suffered any physical abuse, and the harm that they suffered is almost completely psychological or emotional, but it also has often a wide range of impact on their everyday functioning, which we'll talk about. The applicant must have information concerning the criminal activity, obviously. The applicant must have been helpful, is being helpful, or is likely to be helpful in the investigation or prosecution of the crime. The criminal activity occurred in the United States or violated U.S. law, and the applicant is admissible to the United States under current U.S. immigration laws and regulations. Those who are not admissible may apply for a waiver. Certifying agencies can be federal, state, or local law enforcement agencies, prosecutors, judges, or other authority that investigate or prosecute criminal activity. Other agencies such as Child Protective Services, the Equal Employment Opportunity Commission, and Department of Labor may also qualify as certifying agencies since they have criminal investigative jurisdiction within their respective areas of expertise. Non-immigrant status cannot exceed 4 years. However, extensions are available upon certification by a certifying agency that the foreign national's presence in the United States is required to assist in the investigation or prosecution of the qualifying criminal activity. After 3 years of continuous physical presence in the U.S., while in non-immigrant status, a U-Visa holder may be eligible to adjust status and become a LPR if certain requirements are met. The individual also clearly must not have unreasonably refused to provide assistance to law enforcement during this period, since the individual received the non-immigrant visa. There are all sorts of criminal activities that are defined, that are included within the category we're talking about, including abduction, blackmail, extortion, genital female mutilation, hostage, involuntary servitude, murder. There's all sorts of issues involved. The majority of cases that I've seen fall under two broad categories. One is domestic violence, and the second are individuals who are employees in stores, often gas stations or supermarkets, and a robber, most often an armed robber, enters either alone or with another criminal, and at gunpoint demands that money is given by the employee in the store to the criminals. There are several challenges to this area. One is that U-Visa law is mandated federally, obviously, but implemented inconsistently by local law enforcement. I understand that there's sort of a parallel with Medicaid, which is a federal program, but each state implements it in its own jurisdiction by its own rules and regulations. There's a limited number of U-Visas issued each year. Sometimes promises are made by police or prosecutors, and then it is not forthcoming later on, and the challenge is sometimes to get it in writing. And the other significant challenge is support from a forensic evaluator. I say that because it's difficult enough to get a forensic evaluator for I-751 cases, VAWA cases, asylum cases, especially asylum cases with the one-year bar, criminal mitigation, and so on. And I've spoken about in other programs. I think I'm the only criminal mitigation expert in the United States who specializes in immigration defense work. It's even more difficult to get a evaluation for a U-Visa case from a regular clinician because they haven't heard of U-Visas. Many people have not heard of U-Visas. And so there could be a challenge getting a forensic evaluator to do these kinds of cases because they're relatively unusual. I just want to give a very quick comparison to T-Visa cases. To be eligible for a T-Visa, the victim must have traveled to the United States, recruited, forced, abducted, or deceived by the perpetrator of human trafficking, and the victim would not otherwise have been present in the United States if it were not for the actions of that person. Human trafficking under U.S. law is defined based on the 2000 UN Protocol to Prevent, Suppress, and Punish Trafficking in Persons. I will say that I've done many U-Visa cases and I've consulted on many U-Visa cases. I've only consulted on T-Visa cases. I've never actually written one up. This is for a variety of reasons. These cases can be very difficult to understand conceptually. There can be very frightening and traumatic issues in these cases that need to be spoken about, and it makes them particularly challenging. The elements of the crime fall into three categories in the T-Visa area: process, ways and means, and goal. Process refers to the recruitment, transportation, transferring, harboring, or receiving of a person. Ways and means refers to the process, not the process in terms of recruiting, but the processes in terms of the interaction. This means the threats, coercion, abduction, fraud, deceit, deception, or abuse of power, which almost always occurs as a means to have the victim become involved in this sort of activity. And finally, the goal, which is prostitution, pornography, violence, sexual exploitation, forced labor, involuntary servitude, debt bondage, or slavery. Adult victims of human trafficking must prove that the crime involved at least one element from each of the above three, from process, ways and means, and goal. However, child victims of human trafficking need only show an element from the process and goal categories. Another major difference between U-Visa and T-Visa is that T-Visa applicants are not required to obtain a certification of helpfulness from a qualifying agency. T-Visa applicants are strongly encouraged to obtain a declaration from a law enforcement officer as primary evidence that they were a victim of human trafficking, crime to submit with their application nonetheless. Finally, there's an extreme hardship issue, which is that T-Visa applicants will need to show that their removal from the United States would cause extreme hardship involving unusual and extreme harm. And there's actually a wide range of factors, but I'll just note a few of them. First, medical needs. Due to the trafficking crime or for other reasons, the individual victim cannot be met. The individual's needs cannot be met in their country of origin because of a lack of medical care or psychological services. Second, a government will not protect her from further harm or prosecute the trafficking offenders. Third, the victim would be stigmatized in the home country as a result of being a trafficking victim. So, for example, if you were identified as a female victim of sex trafficking, you would be unable to obtain, perhaps you'd be unable to obtain employment or get married or integrate into the community in your country of origin as a result of you being a victim. And really any other factors that pertain to that victim's particular case to support extreme hardship can also be relevant. I want to now look at the conceptualization of harm in U-Visa cases. You know, when I give CLEs, and I've done this for many, many years now, I've had some, maybe 100,000 listeners, I try to have every slide, every PowerPoint slide as being important and relevant and useful. But some programs have one very small area which is which underlines the entire case, and this is one example right here, and that concerns conceptualizing harm broadly. In U-Visa cases, you're looking at a harm-based case, and very often in these cases, the physical harm is not present, or there is minimal physical harm, or the physical harm that is present is considered not serious because of the outcome. So, for example, there's no bruising, bleeding, there's no need for medical attention, and so on. As a result, in these U-Visa cases that can be challenging, to avoid getting RFEs, requests for more evidence, you conceptualize harm broadly, and that's what I want to do for a moment, just to explain what I mean by it. First, look at all kinds of harm for every area of the person's life systemically since they were the victim of a crime. So harm to self, their dignity, their identity, their self-worth, how has that been harmed as a result of being a victim of the crime? Next, quality of life issues. How has the individual's sense of security, stability, their sense of safety been undermined or even jeopardized as a result of being the victim of a crime? Next, what are their deficits and losses in their everyday life, their everyday activities? What sort of interests and hobbies and other kinds of activities can they no longer engage in because they were the victim of harm? Cognitive loss, not just behavioral, but cognitive. Do they process information differently? Do they think differently? Is their memory impaired? Next, ADLs. Are they able to attend to their activities of daily living? In other words, cooking, shopping, self-care, home issues, and so on. Have these been impaired because they were the victim of a crime? Next, interpersonal friction. Has their relationships with coworkers, family, other people been harmed as a result of this? Next, lifestyle changes. You know, has the person made substantial lifestyle changes? I had a client, very interestingly, who was a victim of a crime in a neighborhood that was very important to their lives. They had friends and relatives in the neighborhood. That neighborhood was crucial because they had access to a train that they used every day, and many other reasons. As a result of the crime, the client could no longer use the public transportation system. I won't go into why, but that, for that client, was a substantial harm. The client is an immigrant who could not afford an automobile. The client, you know, had to travel quite far to his place of employment every day, and it didn't seem like, you know, objectively to be the worst thing in the world. But for this client, the loss of his, the inability now of not being able to use the public transportation system was devastating in terms of getting around the city, getting to work, helping get his children to school, and so on. Is there community losses? Is the client isolated, and so on? Has there been loss of socialization and other interpersonal contacts? Has the client perhaps had to change their residence as a result of being a victim of a crime? And has this had a spidering impact on them having to change their employment, friends, all sorts of things? So the one thing that I would have you take away from this is that you need to conceptualize harm broadly to cumulatively show in all the different ways that the victim has suffered harm, especially if there's no clear physical harm, and how all of these harms together, either individually or cumulatively, negatively impact the psychological health of the individual and the emotional well-being of the individual. These evaluations are very broad, they're holistic. all psychosocial evaluations are. In a sense, it's particularly important in U-Visa cases because you want to get a very broad sense of the person's life to see in what way the person's life has been negatively damaged as a result of being the victim. The other place I do this a lot is in asylum cases, actually, because I've often found that in asylum cases, the person will report, maybe just a few very specific examples of harm in their country of origin, which obviously are important to document. But what the lawyer and the immigration judge, whoever's looking at the case, the adjudicator needs to understand is that these several instances of harm that the client has documented in their asylum application actually have much broader implications concerning the client's quality of life and everyday living situation in his country of origin, even in his community of origin and his family of origin before coming to the United States. And looking at that gives a much better sense of the asylum client's everyday losses as a human being in their country of origin concerning their life development, interpersonal interactions, community ties, employment, education, and much, much more. In civil litigation, we have something called the eggshell rule. We all remember from law school. Take your plaintiff as you find him. And we take the U-Visa victim as we find him, and we inquire about the quality of his life now and any harm that he has endured. There may be a predisposition to psychiatric issues due to past trauma. It is crucial to start at that point in the U-Visa evaluation. In other words, we're dealing with immigrants here, and many of our immigrant clients have come from places where they've also suffered trauma and harm because of poverty and misogyny and corruption and ineptitude by the police and government. There may have been alcohol and the ubiquity of drugs in their country of origin, all sorts of problems, poverty. So we may have a client that has already been the victim of harm before coming to the United States, may even have suffered PTSD, depression, other mental health issues. That's a reality, and you take your plaintiff as you find him. And it may, in fact, strengthen the case because this client has come to the United States seeking a better life, seeking safety, security for their family, stability, and then they're the victim of harm, and it reinforces the vulnerabilities, it reinforces the trauma that the person has already suffered. So in this sense, in the eggshell rule, we want to look in what ways the individual has previously been fragile and vulnerable, and how the current harm influences that and qualifies that or informs it. There are many kinds of harms we look at in these kinds of evaluations, and I just want to mention a few that are most prominent. Obviously, physical harm is very prominent. This is obviously true in cases of a direct attack and in spousal abuse cases and so on, with hitting and punching, other kinds of direct physical harm. But there's indirect physical harm that may occur in some of these cases, including in a lot of the cases I see where employees are the victim of robberies. The person may have a gun brandished. The gun does not go off. The criminal does not use the gun to directly harm the employee in the store. But that is a physical harm. The person is being forced into a small space with a gun brandished at them. That is a physical harm. Another major kind of harm is psychological, which often involves control or coercion. But there's also emotional harms, which pertain to feelings. In other words, because of the harm, the person's emotions, their feelings, how they understand themselves, how they understand others, may have been negatively impacted as well. Verbal harms are rarely included in these kinds of cases, but I always like to put it in examples of that. There could be racial slurs, expletives, and also threats. This is very common in U-Visa cases with domestic violence, where the abuser will say something like, I can have you deported from the United States, or if the victim has children, I can have you separated from your children who are here, and those children won't have a mother. Sexual violence, of course, is very well known. Any kind of unwanted sexual touching, financial harm, and so on. There are other kinds of harms also that you need to ask about broadly and that have become very prominent. And those include technology harm. This is a huge area that has developed in domestic violence cases where the abuser, for example, will control the victim's social media, force the victim to give the abuser the passwords to social media or banking or everything else. Our smartphones are basically fantastically powerful mini computers. It's not just for talking. It has all of our information, including contacts and so on, photos, and control of information technology and digital devices can be extremely powerful. The last form of harm that ironically is missed in many of these U-Visa cases is cultural. The U-Visa client is an immigrant to the United States, and in the course of the harm, they may have been verbally harmed or otherwise simply because of who they are, their ethnicity, their personal appearance, their religious orientation, and so on. I just want to give a few caveats to explain harm that will broaden this in tricky cases. The first is that the severity of a single incident can be systemically damaging. In domestic violent cases, you have, and I have this in my other programs, you have victims who've suffered physical, emotional, verbal, sexual, financial harms repeatedly over many months and many years. And it leads to obviously terrible trauma. However, a person can be the victim of a single incident and suffer systemic damage that leads to harm in a wide range of areas of the person's life. Just a very typical example that I've seen many times are, again, employees in a grocery store who have been the victim where a robber comes in, alone or with a partner, with a gun, maybe a knife, and brandishes the weapon, threatens to kill the employee gives the money, and the whole thing is over in sometimes as little as a minute. However, even though it's a single incident, and even though the victim has perhaps not suffered any previous harm or trauma in his or her life, it doesn't mean that that single incident doesn't cause systemic damage to the person's life and well-being. Next, microaggressions add up to systemically damaging abuse. This is very important to understand in many contexts for U-Visas. I'll just give you a very common one that I see in domestic violence cases where the abuser will be verbally abusive, but in not a completely overt way, so that the abuser may insult or harm or say damaging or degrading things about the victim's body, their appearance, their age, their height, whatever, their culture, religious affiliation, over many weeks, many months, many years. These are microaggressions that add up to systemically damaging abuse. Next, people perceive and are affected by abuse and harm in idiosyncratic ways. It's incredibly important to understand that if your U-Visa case doesn't look very strong, consider it objectively, of course, but consider it subjectively from the perspective of the client. I'll give you just a classic case that I teach about all the time. My maternal grandparents were in a serious car accident about 60 years ago. My grandfather walked away from the accident unharmed, never drove the car again, not a day in his life. My grandmother walked away from the accident also unharmed, got in the car the next day, and drove till she was 83. Why? My grandfather was the victim of racism in Eastern Europe as a young child, and he became very risk averse. My grandmother was born and raised in Connecticut, a poor family, but in the United States where it was very safe, and she was not risk averse. She was a risk taker and impulsive. So here are two people with very similar lives in some ways, similar values, a lot of similarities, but because of their psychosocial backgrounds, they perceive harm and dangers in very separate and idiosyncratic ways, and you have to understand objectively about the harm, but you have to understand the subjective perspective of the individual victim. And the last is resilience, an individual's ability to overcome adversity. This is a huge problem. I'm going to tell you why. Because you see, for a couple reasons, but you see clients in U-Visa cases where the individual has suffered a terrible harm because of a criminal that seems incredibly frightening and would be traumatic to you and me, and the client seems fine. It's important to explain the client's resilience and why the client may not be suffering PTSD, but nonetheless, the client has been harmed in other ways in their lives. The other important matter about this is that some U-Visa cases are evaluated months or even years after the criminal activity occurs. And in the intervening months and years, the individual has contended with the issue and they've been able to understand it. Maybe they've gone for therapy. They have help from friends and family. They're able to get back into their lives in a healthy way. And they may not seem as someone who has suffered trauma, but they have. And that needs to be clarified for the evaluation. There are many other issues. I'll just name a few. One is the relationship to the defendant. Where the victim does not know the abuser or the criminal, it's very different than they do. So just a very blatant example. If you're crossing the street and a car hits you, well, the car is liable for hitting you, obviously, but the driver of the automobile has no animus towards you. You're a stranger. A very different kind of case is in a domestic violence U-Visa case where the abuser is abusing a victim. There's a particular sense of trust that's supposed to be there, and there's a betrayal of that trust when the abuse occurs, so that the victim may feel much more traumatized because of the relationship itself. So how the client understands and perceives the relationship and connection between him and the abuser or the criminal can be crucial. There may be unrecognized harms that the client may have suffered in various ways that they're not aware of. The best parallel I give is, in personal injury cases that I've done, you always assume the person is injured. And if the person says they're okay, well, you send them, for radiographic assessments like MRIs or whatever. And if it shows up, that they're fine, they're fine. But, it may show up, obviously, that they have had internal injuries that they're just not aware of because they're minor or for whatever reasons. Similarly, with psychological evaluations, don't take the person's word for it that they're fine. Ask about their daily life. Ask about their functioning and their general health and their interaction with their community and family and coworkers. Because sometimes people are in denial. Sometimes people don't realize the seriousness and the extent of the harm that they've suffered. For this reason, it can be very helpful to get a parallel history from a spouse or other people in the family to understand how the person is coping. It can give you a whole window of insight. It's important to understand that because of this, you really need experts who have done many kinds of evaluations in forensics, and including U-Visas, to evaluate these questions so you can really adequately get at the issues. The example I always give is with spousal abuse cases, and you have that in U-Visas, where You have to ask very directed questions in these kinds of evaluations. It's not therapy. In therapy, it may take weeks, it may take months, it may take years for the patient or client to speak about very painful issues, including sexual abuse and so on. You don't have that in a forensic evaluation. Forensic evaluation, you have 1 or 2 or 3 hours to interview someone and to get at the very core issues of harm that they've suffered and in what ways it has negatively affected their lives. You want to get at detailed memories if possible that has specifics about what the person has experienced. People tend to remember things that are very outrageous, right? Something that is exceptional or out of the ordinary. Another memory tends to be very qualified. For example, and I've seen this many times, I'll see a female victim of domestic violence who suffered, 1,000 verbal assaults in the home where she's degraded and so on. And they sort of collapse into a single memory of verbal abuse. And then one day she goes with her husband or partner out to a restaurant with her family, and the abuser verbally abuses her. And that she never forgets. Why? Because she's in public with her family and she feels acute sense of shame, maybe even guilt, and that she remembers. So memories can be outrageous. That's one way to remember it. Another one is qualified. And the third are memories that are simply impossible to forget. And the most common are those where the individual retains a physical scar due to violence. You don't want clients to under-exaggerate. You don't want clients to over-exaggerate. Allow them to provide a clear narrative that is as accurate as possible. I want to take a few minutes now to look at psychiatric issues, the most prominent of which, of course, is PTSD. Here, the person's exposed to death or threatened death, actual or threatened serious violence or sexual violence. What's important here is to understand, again, objectively what occurred, but just as importantly, subjectively, how that person experienced it. Never forget my grandparents. My grandfather never got in the car again. After the car accident, my grandmother got in the car the next day. There are often symptoms of intrusion where there are repeated nightmares or thoughts that are intrusive that cannot be gotten rid of. There can be intense or prolonged distress after exposure to traumatic reminders that trigger memories of what occurred, including something that could result in physiological reactivity. Many clients show avoidance, that is, they don't want to deal with anything that reminds them of people, places, conversations, activities, situations, anything that reminds them of the trauma. Many clients experience negative alterations in cognition and mood. They have an inability to recall what has occurred. They may have persistent negative beliefs about themselves or the world. There may be self-blame and symptoms of various kinds related to depression and anxiety, including feelings of isolation, diminished interest in daily life, and constricted affect. That occurs where the person really does not feel they have a need to experience positive emotions with other people, including perhaps even family members. And finally, alterations in arousal and reactivity, where the person may be very irritable, angry, aggressive. There may be self-destructive or reckless behaviors. Some of these clients can become quite hypervigilant, even guarded, paranoid, distrustful, and that may result in problems with focus, sleep, appetite, and so on. Many clients who've suffered trauma in these cases suffer from a depressed mood. Sometimes nearly every day is indicated by subjective feelings of sadness and emptiness and crying, with hopelessness, low energy, feeling that they just have no interest in activity of daily livings that they maybe previously enjoyed, such as personal hobbies. The person may have, chronic fatigue, feelings of, I just can't get out of bed, loss of energy, feelings of worthlessness, guilt, There may be difficulty with sleep and appetite, even nightmares or bad dreams, and overall a diminished ability to think or concentrate. Some clients that are the victims of trauma may also suffer suicidality. They may think, maybe it's better if I just sleep and sleep and sleep so I don't wake up, so my psychological pain will vanish. They may be active suicidal thoughts where the person thinks, I can take a bottle of pills to end my life, or passive suicidal thoughts where the person thinks, maybe I can just sleep or something can happen to me passively so I don't have to contend with overwhelming feelings of despair and deep psychological pain. Some clients experience panic attacks, which are recurring. They're often unexpected. That's when your heart goes very fast, you're shaking, sweating, feeling discomfort, nausea, dizziness, fear you may lose control, that you're going crazy or dying. You may have numbness or tingling, and you can even have chills or hot flashes. Although they're recurring and unexpected, they're often triggered by something specific. Some clients, especially those who are victims of domestic violence in long-term relationships, may have learned helplessness, a condition in which a person suffers from a sense of powerlessness arising from a traumatic event or persistent failure to succeed. And these clients may have underlying depression or anxiety, experiencing shame, humiliation, worthlessness. They may feel unloved. They may endure self-blame, guilt, or even a concern for other family members. Very importantly, many of these clients, it's not often recognized, suffer with psychosis, often adaptive. I used to see clients that came out of jail and they developed adaptive paranoia. They were always felt they had the need to look over their shoulders and be quite guarded and suspicious of others. And that's quite normal and adaptive in that kind of situation. And it may be normal and adaptive for your client who has been, again, the victim of domestic violence. There are two basic kinds of psychosis, which basically means out of touch with reality, and they concern hallucinations, which are false perceptions, such as hearing things that are not real, and delusions, which are false beliefs. The most common kind of hallucinations for victims of spousal abuse, for example, I'll ask a client, do you sometimes walk down the street and you hear your name being called, you turn around, but nobody's there? That is an auditory hallucination. The most common visual hallucination are people who have been the victims who at night think they see shadows or the outlines of a person. And this is, of course, the victim being quite hypervigilant regarding their safety, and they think they see someone, their mind is playing a trick on them. There could be dissociative disorders. These are conditions that involve disruptions or breakdowns of memory, awareness, identity, or perception. People with dissociative disorders use dissociation as a defense mechanism, which sometimes, again, may not be apparent at all, but should be asked about. When flight or fight are not available, then the only option is psychologically, emotionally removing yourself from that situation. Flight responses, you see a bear in the woods, you run. A fight response, you see a bear in the woods and you fight. Clearly, with some threats, running away and fighting are just not options, and the bear in the woods is a great example. So what do? And there are two other F words. One is fawning and the other is freezing. Fawning means you placate the threat in such a way that you try to match its emotion and behaviors so that you calm down and the threat calms down. Freezing is just what it sounds like, where you become like a stone. You don't move, you don't breathe, you barely move your eyes, and you stay that way until the threat passes. Many people who've been the victims of harm turn to alcohol or drugs. This is a great indication of how the person self-medicates, and it's also a great indication the extent of the seriousness of the harm that the person has suffered. Some clients present with atypical situations for all sorts of reasons. There could be subclinical issues, and this is often because of cultural sensitivity that needs to be asked about. I'll see people, for example, who have really come from cultures where psychiatric care is anathema to their cultural background, and mental health diagnoses are stigmatized. They never think about getting mental health support. Some go to their churches where they find spiritual support from their pastor or other parishioners. Some clients just want to leave well enough alone. But these clients may not recognize that they have suffered reactive depression, anxiety, PTSD, or whatnot. And again, we want to look subjectively at what the client is telling you, but objectively, in a traumatic situation, we would expect some kind of emotional or psychological response that needs to be inquired about by the forensic expert. Some of these clients really are terribly ashamed of what has happened. They may not have the financial resources to obtain proper psychiatric care. They may fear authority. They may not have sufficient English language skills. Some survivors, and I see this all the time in asylum cases, especially sexual identity asylum cases, issues which I'll present on YouTube in another week or two. They can't imagine that anybody would possibly understand their experiences in their country of origin, the human rights violations or persecution, because it was so subjectively horrible and they don't want to talk about it. It may also be the case that, when the evaluation is being done, it's the first time that the victim is openly speaking about these kinds of issues, and it requires sensitivity on the part of the forensic evaluator. But it needs to be balanced, as I said before, with an understanding that this is a unique and important opportunity to document it for the benefit of having a petition that accurately reflects what occurred to the victim. Thank you for listening today. This is an outline of the challenges and issues that forensic evaluators have when undertaking U-Visa cases. Please don't hesitate to email me if you have any questions or call. I'd be happy to send you a redacted copy, and I'm hopefully going to continue to provide the entire series of CLEs that have only been available until now for a cost. They will be available to everybody through YouTube. Thank you for listening today, and I hope this was helpful.